Thank you very much for joining us this morning. It's a pleasure to have you here for this joint webinar between DMH Stallard and Menzies. This morning we're looking at working outside the UK and delivering on contracts in Europe post-Brexit. By way of introduction, my name is Nick Farmer. I'm an international tax partner at Menzies. I'm joined today by Adam Williams, partner at DMH Stallard, and Sanjukta Ray from the Menzies Global Mobility team. Now, the reason why we've come together really to deliver this webinar is that our specialist areas interact highly. If you look on the screen, the Venn diagram which we've put together just shows this overlap between the different sections. I particularly look at the business taxes. Sanjukta looks at the global mobility, the payroll and the national insurance issues, and Adam looks at the employment and immigration issues. There's one key aspect that's probably missing on that slide, which is absolutely crucial to this advice, which is the overseas support that we require, that on the ground local advice when we're piecing together the cross-border tax position for businesses. And we're both fortunate in the fact that our firms are parts of international networks, that we can source that local advice and we can make sure that we're reflecting the local position back in the overall issues that affect the business when they're moving individuals across border. So the structure of this morning anyway is that firstly, we're going to look at the here and now, the issues that are arising from the pandemic, the displaced workers, people working from home in remote locations. We'll each run through our thoughts on that, and then we'll have a question and answer session. So please do place your questions in the chat. We'll then move on to look at the post-Brexit environment of doing business in Europe, winning contracts in the EU, and how you deliver on those. And again, we'll run through our own thoughts, and we'll then sort of take some Q&A on that. I think we've got quite a lot to get through actually in the next hour, so I think it's going to be quite a full hour. So we'll keep things moving between the three of us and keep it quite interactive. To start with, Adam, I think you're going to launch a poll, just some questions that we thought would be useful to understand as to exactly who's out there and listening this morning.
Yeah, absolutely, Nick. Thanks. Yeah, we just want to get a sense from everybody in the room of your experience so far. So the first one of our two initial polls are, have you had employees working for you outside of the UK during the pandemic? It's just a yes or no. So if you can let us know as employers whether you've experienced this. I'm hoping that none of you have and don't know it by now. That is certainly has occasionally been experienced that we've had with clients finding out after the event. But yeah, if you can vote yes or no, we'll just see the results come through on that. And while we're waiting, if you have any technical issues, please put that in the chat column and one of the team will help you with technical issues. Questions for later, put in the Q&A, please. Okay, results are in. Yeah, well, it doesn't surprise us because we're very pleased to see how many people are on this session, and reflecting that we've got nearly 75% saying you've got employees working for you outside the UK during the pandemic. So overwhelming majority have that situation or have had that situation. The second one is to get a sense of in which territories you do or will do most business internationally going forward. And this is really looking to the second half of today's session about the forward-looking piece around doing business internationally. So it's a binary one. You have to pick which of those territories you think is your most active or will be your most active territory. I'm expecting we'll see a spread here, some mix. I don't know about Nick and Sanjukta, maybe we're guessing there might be a weighting towards Europe.
I think it's, yeah, Europe or North America, I would expect to be the two most dominant territories. That certainly would reflect our sort of experience of where we're seeing most demand for support.
Absolutely. We're just waiting for that to flow through. Yeah, okay, so Europe 74%, North America in at 16%, and then we've got smatterings of roughly 3% and 1% for South America and 3% for each of Africa, Middle East,
So
and
that's
Asia.
good, Adam. I mean, that really reflects where we're sort of going with this webinar anyway. So that's great. You know, a lot of people out there are sort of seeing the sort of issues that we're going to be covering here this morning.
Yeah, exactly. And although a lot of the stuff we talk about today will be relevant to rest of the world, not just Europe, we've put an emphasis on Europe because that's where the big shift has come, of course. And why many people are on this session today is getting a sense of the European position in the proper post-Brexit, post-transition period situation. So I'm going to spend, each of us, me, Sanjukta and Nick, are going to spend 5 minutes in the first half of today's session talking about the situation that's been present for almost all of you, vast majority of you, and probably is still happening at the moment in relation to the pandemic and working outside of the UK, which there's been an increase in that sort of activity because of the pandemic. We're each going to look at that for just a 5-minute overview of our take on it in each of our respective areas, and then we'll have some questions and discuss the issue. Really, the intention is to give you a good introduction / overview to the sorts of things that you need to be thinking about in this area. I'd pick up on Nick's point to start, which is the importance of local support and having that network of local support. That, from the immigration perspective, which is what I'm going to talk to you about today, was pretty much non-existent as a requirement when you're looking at moving people in and around Europe. Whilst the UK was a member of the EU, because we had free movement, and just as it was bringing an EU or EEA national into the UK to work, was the same sending a British national, for example, into Europe. You essentially just had the right as an EU citizen to freely move around the EU, to look for work, do work. It was very broad and straightforward. The big shift, and one of the takeaways, which I'm sure most people are already acutely aware of going into this session, is that Brexit has obviously brought a sudden end to free movement. And now what that means is that the local support and advice and the local rules on rights to work, business visits, all those things become very important. And it's been an issue that's kind of bubbling underneath during the pandemic, when you might have had people working in different locations. That may have started before the end of the transition period, but now we're out of the transition period. The big question becomes, if we've got someone working for us outside of the UK, for example, an EU member state, what is their immigration status if we've got an issue there? Now, I'm going to just canter through this over just a couple of minutes, but you've got a variety of different remote working scenarios in terms of the activities being done, the type of role that the individual occupies, the frequency, if they're not in that host country all the time. And so you have to bear in mind that the issues you face or the options you have may differ depending on the individual and their scenario in terms of their level of footprint and what they're doing in the territory. So the immigration picture can be simple or complex, depending on things like nationality and the host country. Different host countries have different rules. Obviously, whether you're looking within Europe or outside Europe, that may be the case. Take an example of a French national who returned to Paris during the pandemic and has stayed working there. You would expect that to be a pretty straightforward immigration picture, as long as they haven't renounced that French citizenship. They're in their country of nationality. Contrast that with Canadian national who's in a European country, had a right to work and live in the UK, perhaps what was used to be called a tier 2 general visa, doesn't have any right to do that in the European country, let's say Spain, went there on a business trip or holiday and was stuck there, and has since just decided that it works for them and stayed. Maybe a much more complicated picture, just because of the different nationality, possibly the different rules and how they translate into that individual. There's been COVID-related relaxations and concessions, informal or formal, had lots of those in the UK around immigration requirements, delays to people's need to return to country of origin when their visas are expiring, so exceptional assurance, we call it. There will be similar relaxation and concessions to varying degrees in different countries where the individual might be. The main point to note is they're probably being wound down, possibly have been removed. And so you need to understand whether you still benefit from those and what you're left with when they're taken away in terms of, say, another European countries relaxations of the rules, or more informally, it may be that country is now starting to do more of its immigration checks and visits, and that the risk of something coming to light is higher. The main point I'm making here is the issues and requirements will differ from place to place, because we've got 26 different EU member states where we don't have free movement of British nationals in and out. So if you've got a British national in one of the EU 26 states, you will have a different set of rules potentially to a British national in another member state. So it's important to engage experts. You've got to look at the past, the present and the future position. There may be trigger points under the local immigration rules that you either do or don't want to go past. And you need to work out the actions that are required, which may be relatively few if it's a straightforward backdrop, or quite a lot. And in fact, they might be quite urgent. I'd also just touch on before I hand over, thinking about longer term. So once you've established, for example, that it's okay for somebody to carry on working in the country that they're in, we took the Spain example, didn't we? Think about what that might do for the longer term, though. If the business actually expects them to return to the UK to live and work at some point, their stay outside of the UK may have implications. So, for example, in fact, if you take an EU national, they may have pre-settled status because they were in the UK pre-Brexit, and that's a 5-year period to work towards the right to stay in the UK indefinitely. Well, being outside of the UK for 2 years would most likely sever that status, or even if it's less than 2 years, they might return and have not had one of the necessary 5 years in the UK to get to the point of proper settled status after 5 years, and they have to effectively reapply for pre-settled status and start that 5-year clock again. So think about that. And also, I'm sure it will come up in the questions, don't forget about employment law. We've got quite complex, particularly in Europe, quite complex rules about how and where and whose employment laws and rights apply under things like the Rome Convention and the Posted Workers Directive. There's an important piece to do there to identify what obligations and duties and rights might arise. So that's a quick overview of the position in relation to immigration. I'm going to hand over to Sanjukta because, and I think it's helpful that we've done it, that I would start and then Sanjukta would follow on from me, or it could have been the other way around, but because there's a particular overlap in issues here, and it's easy to confuse immigration issues. For example, the fact that you can be a visitor for up to 90 days in any 180-day period under the Schengen visit rules to Europe, with other issues around tax, payroll, benefits, where there might be another set of days that you're looking at in terms of presence in the country, but they will not be the same, and they don't relate to the same issue as regards to immigration, for example, income tax and payroll, social security. So anyway, I'm going to hand over to Sanjukta, who's going to give us an overview of her aspects of all this.
Thanks, Adam. Thank you. So as we've seen that the pandemic has accelerated the speed at which employers have asked or have allowed individuals to work remotely. Now, at the start of the pandemic, people were probably stuck in or stranded in overseas jurisdiction. But fast forward a year and a half, we have seen that individuals have continued to remain in those overseas countries and they carry on working remotely. And the employers, in the most part, have been okay to facilitate that. And perhaps because they've noticed that productivity has not been affected, the employees are happy. So why not let them carry on? And sure, that's great because we do have the technology to support it. However, all of these arrangements inevitably come with their own sets of risks and considerations. Note here, though, that we're talking about remote working in the context where the employer is based in one country and the worker in another overseas jurisdiction. So from a global mobility perspective, the key issues for employers to think about in these remote working scenarios would be things like, well, is there a possibility or is there a need to have some local reporting, or is there a local reporting obligation? Do they need to run a payroll or a shadow payroll in that overseas country, in addition to the payroll that's perhaps already being is being run in the UK? Do the employers have a need to register for withholding taxes? Do they need to register and pay over social security contributions? And what happens to the additional costs that all of these issues bring around? So, for instance, if you've got a remote worker who is working from France, and it has been deemed that social security contributions are necessary there, straight away we see that the employer's costs will increase from 13.8% in the UK to up to about 45% employer contributions that are necessary in France. So you have all of these things to think about. And then there are the wider sort of tax risks in relation to permanent establishments. Has the employee created a corporate presence? And Nick will talk about that in detail a little bit later on. So then what Adam talked about, employment law. Well, if you've got a person who's living and working from another country, maybe the employment laws of that land will apply in the event of a dispute. And what about the eligibility to work? If they've gone, if they're working in a Schengen area, for instance, they might be okay to visit there, but are they really eligible to work from there? I mean, yes, they are working remotely, but there's still a risk. And Adam has touched upon that already. And what about the health and safety aspects? What about the duty of care that the employer has for these individuals? How is that being extended in the overseas jurisdiction? Medical insurance, well, they might be covered. They might have private medical insurance to their employers back in the country of employment. But does that then cover them also in the event that something happens in that overseas country? And then from the employee's perspective as well, well, they might have these ongoing cash flow issues if there is a need to withhold wage taxes in the overseas country, as well as say in the UK, and at each month there's a deduction of taxes on the same income from two countries. Yes, once the year is over and you file tax returns in both countries, you will be able to claim treaty relief or foreign tax credits, such that you do not pay tax twice on the same income. But month on month, you might have this cash flow issue. And their personal tax implications. The individual might have a filing obligation if they become resident, or they might have a filing obligation anyway as a result of their presence and work from that country. And they might suddenly find that they have an obligation not only in relation to their employment income, but also tax implications have been triggered for their worldwide income and gains. And for Social Security, if it does become payable for a short period of time in that other country, what then happens once they come back? How are they going to sort of accumulate all the benefits that they can derive from it? So all of these sort of issues inherently carry some risks, and the main one is the risk of being non-compliant. You're not aware of what those issues are or what these issues could be, and you've not done something that you should have done. And suddenly, as Adam said, that once tax authorities have started coming to grips with the pandemic, their concessions have lapsed. There is going to be more scrutiny, and suddenly the employer might run a reputational risk, and the risk rating might increase in the eyes of the relevant authorities. And if you wanted to do business in future in those countries, there might be greater scrutiny. So what I'd like to say is that every situation here is different, and every country are going to apply the rules differently. It is really important that you assess each individual scenario on a case-by-case basis, and take the action that is appropriate for that particular scenario in relation to that particular country. So on that note, I'd like to hand over to Nick, who's going to talk about the business tax issues.
Thanks, Sanjukta. And I think you can see from both Adam and Sanjukta's presentations the sort of high level of overlap. Here I'm specifically going to be looking at the business tax side of things, especially those which have arisen from this displaced workers, people being in remote locations. These issues have been looked at quite carefully during the pandemic by both the OECD and there's been country guidance given. The two issues that they particularly look at from a business tax point of view is whether there's a permanent establishment in the jurisdiction, and permanent establishment is really just whether there's actually a business presence, whether you've got to a point that actually you should be registering to pay taxes in that jurisdiction because you are established there. So you've got a presence that's significant enough to give rise to needing to pay business taxes there. And the other one is whether actually the company itself may have changed its residency position by having key personnel based in new locations. The area really to focus on, I think, is the permanent establishment side of things. The risk around corporate residency is less. Around permanent establishment, this can typically arise. The UK has a wide treaty network, but it typically arises if a company has a fixed place of business in another jurisdiction. It may have somebody there that we'd regard as a dependent agent that can conclude on contracts on behalf of that company. There may be an installation or construction project taking place. Under some treaties, it's actually possible that a permanent establishment arises through carrying on services in a country, say for a short period of time, particularly thinking there of the UK-India tax treaty, where more than 30 days spent in the country can give rise to a permanent establishment. And there's various exemptions. Probably the big issue that's arising, certainly now, is this employees working from home in a remote location, and whether that in itself gives rise to a permanent establishment. If you look at the OECD and the country guidance, they're all really sort of saying, if this is temporary, and say, for instance, Austria has said, if it's not the norm, or New Zealand has sort of said, actually, if it's just temporary, it can't really be a fixed arrangement. And I think Australia have sort of said something along the lines of, if it's temporary and the person returns home, sort of as soon as they can, then again, they won't be classing it as a permanent establishment. So I think over the sort of period where there was restrictions on travel, employees couldn't move away from their remote working locations, tax authorities were very sort of understanding that in itself shouldn't create this kind of fixed place of business for a company. However, I think we're sort of starting to get to that point now where, as Sanjukta said, people are starting to work from these locations and see it probably as the way that things may happen in the future. And so you get to the sort of point of asking the question, can that new arrangement actually give rise to a fixed place of business and the company needing to register for business taxes there? There's not a lot of guidance around home offices. Interestingly, the Danish tax authority have probably been most active here. There's 3 quite recent rulings that they've given. One quite recently in relation to a German company that has had a sales and the head of sales based in Denmark. And his sort of role would be that he would be out meeting with customers, couldn't conclude contracts, but about 25% or so of his time would be working from the home office. And the Danish tax authority concluded that would create a permanent establishment there, because there was a continuous use of the home office. The individual was carrying on what they regarded as core activities, i.e. ones which were actually very key in the profit making of the business, and that to some extent the home office had been put at the disposal of the company because they would otherwise need to provide that home office to they'd otherwise need to provide a separate office to the employee. So I think the message here is that we're getting to a point now that if you do have remote employees working in jurisdictions where you're not registered from a business tax point of view, you need to have a very close look at it to see whether it could give rise to this home office PE. And actually, if that's the intentions going forward, whether you actually may do better to establish a company or a new subsidiary in that jurisdiction rather than run the sort of permanent establishment risk is obviously a question to also ask. So I think I'll break there. We'll probably go for some Q&A. Adam, there may have been some questions that have come in around what we've just talked about, and we'll sort of pick up on any particular points through that.
Thanks, Nick. Yeah, I think that we've got some questions come through. It'd be helpful to try to, through the question and answers, how should we say, unpack that a little bit. What I think is helpful you can see listening to the 3 of us there is the importance of having that complete picture. So from the examples we've just given, you might find that the person can stay longer in the country that they're in outside the UK, relatively easy from an immigration perspective, relatively easily. and also that benefits, payroll, social security, you can get comfortable with that and set that up as a business. But then you find that from a business tax perspective, you might be moving out of the rules and the comfort of the working temporarily from home, as I think you described it, Nick, to risk of a fixed place of business, the sort of home office issue. And maybe that last bit of the three areas is the one that informs a change to what your approach would otherwise have been. So that, you know, the three areas are really important. And I think just one other thing I was going to mention that I reflected on from the way, you know, we work together in this area, the overlap point you raised, and Sanjukta talked about medical insurance. And of course, that has legal risk management and practical needs sitting behind it, but also it overlaps with immigration, because if the person's in the European territory, relying on being a Schengen visitor for business, they're going to need at least €30,000 of cover from a qualifying insurer that the EU accepts as an appropriate insurer. So it can also have a particular requirement from an immigration perspective. So that overlap, I think, is the message that's coming out. Some questions. One for Sanjukta, if I may. We've got a question here. If staff are on the roll or payroll of UK company working remotely from an EU or non-EU country, the question is put, temporarily, what will the tax implication be potentially? I guess there's EU and non-EU there, just to pick up on. Appreciate that's probably not easy to answer briefly.
Yes, so, well, the implications will be there depending on, and again, the key here is it depends on the individual circumstances, it depends on what those people are doing, how long they've been there for, and yes, there would be, from an employer's perspective, there may be a need to register for and run a payroll, there may be a need to pay over social security, or they may even be a need to withhold wage taxes. So simultaneously in the UK as well as in that overseas country. And you really have to look at it on a case-by-case basis. So all of these issues are most likely to arise, especially if you let that remote working situation carry on indefinitely, then yes, most likely these issues will be there. The employee would have their personal tax implications as well. They would probably need to file tax returns, or if everything's been withheld correctly through wage taxes, then there may not be a reason or need to file taxes. But there might be other tax implications for the individual himself. You know, he might be subject to some other kinds of reporting requirements. So again, look at it on a case-by-case basis.
Yeah, thanks, Sanjay. I mean, moving over to the business tax then, Nick, as well. Got a question here that somebody would like to understand the rules about working abroad in terms of how they impact small as compared to large companies. Their understanding is that small companies with only one of their many employees abroad are unlikely to face any issues as they don't create a PE or permanent establishment. And are there any different rules for junior as compared to senior or director level staff?
Yeah, okay. Just picking up on those issues, there is no sort of technical differentiation between a large and small company from a permanent establishment perspective. Probably large companies more on the radar of a tax authority, probably more tax at stake. But small companies still have the same issues that they've got to deal with. They're still looking at the same treaty provisions between the UK and where their employee may be based. So, you know, even if you've just got one person working from a home office in another country, you've still got to look at that and decide whether that is a sufficient presence in that country to give rise to a permanent establishment, and hence, you know, a sort of a liability can arise there from a corporation tax perspective. So just looking at the sort of issues around sort of junior and senior staff that were mentioned there. I mean, what you're looking at is what that person is really doing through that home office, and whether they are what you would regard as carrying on the core activities of the business, something that's leading to the profit that that business is making. Because if they are, profit that they're sort of helping to generate can potentially be taxed in that location. On the other hand, you may have somebody who's quite junior, they're not really involved in the key sort of activities of business. They may be perhaps doing a more sort of administrative function, something that we would sort of call auxiliary to the actual core activities of the business. And there's carve-outs for that, which would typically say, well, look, that's really not going to be sort of generating any profit, and tax authorities accept that actually that in itself wouldn't give rise to sufficient presence for the need to pay business taxes there. So, I mean, echoing Sanjukta's comments here, there's key themes, but this is on a country by country basis. Different tax authorities do view this differently. There's limited guidance, as I say, out there. So I think if anybody does have an employee working from a remote location, however large or small their business is, they need to have a closer look at it now, if that has moved beyond just being a temporary arrangement.
Yeah, and we've had lots of questions coming in. That touches on one, an individual saying, to what level can we be sure of the position if the guidance is not entirely clear on temporary presence, and how long can that comfort that we get last? What you're saying seems to be, Nick, is you have to get as close to the guidance as you can, and then make sure that you stay on top of it in terms of
there's always been a rule of thumb that if you're not in a jurisdiction for more than 6 months, then actually you've probably not got sufficient presence there to be sort of a fixed place of business. That's more temporary. But a lot of these arrangements are clearly running for more than 6 months now. They're going beyond the time where employees could return to their home country. Employees are now choosing to stay there, and employers are letting them stay there. And I think that's where things are switching over. And possibly, you've got to take a closer look at that to see whether the business itself should be registering or setting up a new entity in that jurisdiction.
Yeah, we've got lots of questions coming in, some of them quite specific, and I know the three of us are happy to talk through and support employers with these issues. Some of them we can't really go into all the aspects of for the Q&A, but that does touch on one aspect of one question from RF. I'll just give initials so that I don't identify anybody if they didn't want to be. We're talking about somebody being in an EU home country of theirs. They've been working there for 5 months. They've got no return flights, but what are the risks? Well, we won't touch on the payroll, social security, immigration side of the risk, just because that's taking us down another area. But on your piece, Nick, what you've just said tells us that they're potentially approaching a business tax risk territory, because they're at the 5-month mark. Depending on how that's set up, they might be about to shift into a new phase.
Yeah, absolutely. I mean, it is sort of, depending what that individual is now doing in that location, whether the employer is sort of saying you can stay there permanently, or whether they're saying that you're going to have to come back in the future. If they've been there 5 months, they may have got a little bit longer to run to work this out, but this is sort of based on the length of time that you're there, because it's asking, are you fixed? Are you actually permanently there? So, businesses may do well to document their intentions. If their intentions are that employee is going to be there for 2 or 3 more months and then come back, you'll possibly be okay. But if they've actually now sort of moving to the point of making a decision that employee is actually going to stay there, then that's a different matter. So I think this is about intentions, and some good documentation, if that is still just going to be a temporary arrangement, would be worthwhile.
Yeah. I'm going to pick up a couple of quick, sort of linked points on the immigration side. One of the questions was, how easy is it to get a sense of work permit requirements for British nationals in EU member states? We'll touch on this in the second half of the session in more detail anyway. The answer is it's a real mixed bag. Anecdotally, our experience has been that in some member states, when you go and look and ask and try to get a sense locally of what the rights coming out the back of the Trade and Cooperation Agreement might be, or other rules and requirements for British nationals, even the local labour centres that you might be talking to aren't yet clear on what their government's position is. And that's probably part of the fact of the Trade and Cooperation Agreement being signed in December. Countries coming out of the pandemic still getting their heads around it. So it really varies, and it will be a bit of a mixed bag. Early engagement will be helpful, of course, because it gives you the best chance and time that you can to get things lined up. And the other question was, who owns the employment rights and has jurisdiction? Well, this is a point that Sanjukta raised. When we look at Europe, which of course we're focusing on, given that that's overwhelmingly where people are saying they'll be trading, you've got the Rome Conventions. Very quickly, it's a technical, very complex area of law, but one of the rules there is that where there's a weaker party to the contractual relationship, which the employee is taken to be, then the law will usually be the country in which the employee habitually carries out work. That's one of the key rules. There's some disapplications for that, but that tells you in very simple terms why you can seek to choose a set of laws and rules that you think will apply, but in the European context, it's very often you look at it and say that's not necessarily going to be the complete picture. So that's just touching on that area as well. Okay, thanks everybody. I think we're going to move forward now into our second session. As we've said, there's lots of questions. We knew that we'd have a lot, and it's great to see everybody's actively looking at this. We're not going to be able to cover them all in the session today, but as I've said, we're happy to arrange to talk through and support businesses looking at dealing with this. But we're moving on to doing business in Europe now. So we've been looking at how do you deal with the fact that people have been outside the UK through the pandemic and sort of reacting to that. This is more of the proactive bit. So we've started, and we'll start with Nick, given it's proactive and it's about business planning. We're going to start with Nick looking at the business tax position.
Yeah, thanks, Adam. And this is where we're starting to see lots of questions come. It happened sort of pre-Brexit, people thinking about their best way of operating in new environment. With the now we have the trade and cooperation agreement in place, so that does help clarify the arrangements. But clearly, no longer in the single market or the customs union. People have to think more about the structure of how they're operating. I think the point I just wanted to make at the beginning here is that whatever structure you put in place, it does need to be commercial. It does need to have that substance behind it. I do see questions, people asking about sort of lower rates of tax around Europe. There are Ireland 12.5%, Hungary 9%, Malta possibly even 5% with the way their dividend structure works. Yes, these rates are there, but whether they are commercially going to work for business to base yourself there is another matter. So I think some of the things that we talk about to clients are really around, what are the customers looking for here? What are their requirements? I mean, quite often the customer may only really want to trade with a local business, not necessarily with a UK company. I've seen that in one or two instances, not a whole lot. So normally trading with a UK company is absolutely fine with European customers. There may be some local law reasons why you actually need to be established in the EU rather than trade from the UK. Specifically, the clear example there is around financial services and access to the market, but it may happen in other instances in other countries. And a point you made earlier, Adam, is about the fact that this is now all separate countries that you're having to deal with. Every country in the EU has its own local laws, so you need to look at those to understand how you can best trade in that country. And what we were talking about earlier around this sort of length of doing business in that country, if you've got a contract that's going to span a number of years and you're going to have people on the ground in a particular location, then that's the sort of thing which may make you set up an entity there. Whereas if people are just dipping in, going from the UK for short-term visits in delivering a contract, less likelihood that you're going to give rise to that permanent business tax presence and actually the need to set up an entity or register for business tax purposes. So some of the structuring here is really around sort of future intentions. What sort of contracts are you winning? Where are they needing to be delivered on? Are you going to be hiring people locally? You're going to have boots on the ground. All those sort of issues will sort of affect the way that you may structure it. But starting point, in my view, is always, can you trade from the UK into the EU? And are there reasons why it may be preferable to set something up locally? So looking at the business model is now something which we'll spend a lot more time doing than we did previously, where part of obviously the EU, it was much more free and easy just to trade with a UK company. Now we look a little bit more about the best business model for operating. Point worth mentioning, I think, is that there are tax treaties with all the EU countries. They do clarify the tax rights. That has not changed. Those tax treaties remain in place. They will clearly be very important to determine whether a local taxing obligation arises in another country. Not all taxes are treaty taxes, though, so that's worth being aware of. So VAT falls outside of the tax treaties. What I refer to as SALT is the state and local taxes. US is a clear example where you look at 50 states and have 50 different views on how things can be taxed. There's a few countries in the EU, maybe Switzerland, Germany, they do go to a very local level, so you have to look at those sorts of issues. And something like, the UK construction industry scheme, if you're in construction, delivering on installations, etc., there may be some local taxes there that you need to register for. So piecing together the jigsaw really of the right entity to trade through and how the tax is going to arise and how relief is going to get given for those foreign taxes back in the UK if you're paying foreign taxes. Typically, because of the treaty arrangements with the EU, there shouldn't be double tax. This is really just about who has the taxing rights, and that relief for the tax should be given back in the UK. And understanding that, before you actually contract with a customer, and making sure that you understand the way that profit is going to flow and where it's going to be taxed is really worthwhile to make sure that your pricing on that contract is thought through. So we are seeing a little bit more around establishing a foreign entity, setting up somewhere in the EU. Obvious countries that we see if you're trading in goods, we're seeing a lot of clients look at the Netherlands. Services, perhaps not such clear choices or decision making around that. We've seen people set up in Ireland, Spain, Italy, a variety of countries, Poland, a variety of countries, just depending on where they're finding the talent, where their customers are based, what are the local tax and legal rules. They are a factor, but this typically isn't always driven by tax. As I come back to my first point, I think the commercial aspects here are paramount, and the tax then needs to be included in the thinking. So anyway, I'll pass over back to you, Adam. I think that's possibly set the scene around doing business and the way you may sort of structure yourself, and get your thoughts here on the immigration side.
Yeah, it's very helpful, Nick, because one of the bits you just picked up on there was the different drivers to where people are going to set up and operate. And from an immigration perspective, as you know from things from clients we've worked with, we've got Ireland comes up, and that's often where the immigration picture is particularly important, and the client knows that they can get access to the right sort of talent and labour market from Ireland, because if you're an Irish national, you still benefit from free movement. So you would be looking at that, Nick, with the client and us saying, well, what does that mean from a tax perspective? That would all be weighed up as against the benefits of using somewhere like Ireland as a springboard into Europe. So that's been a helpful intro to the immigration piece. But really, I just wanted in the brief sort of summing up is deal with this first question of, with the end of free movement, what are we left with? It's been something of a delayed reaction, because with COVID, of course, the borders have all been shut, and they've been opening and closing, and it's been easier or harder to move around from country to country as a result. And so that's had an impact on the issue. And helpfully, I guess, it hasn't made such a pressing issue for employers and pressure on with regards to being able to move people around. It's also meant, I think, the member state implementation of the trade and cooperation agreement around their approach to mobility has been delayed as well. Hence, when I gave the example of, you go to some countries at the moment and you can't get absolute clarity on what the local labour offices are saying the rules are. But what are we left with? Well, we're left with the sort of legacy of the EU and the Brexit rights. So you've got the EU settlement scheme and frontier workers schemes, and those are the names given by the UK to the arrangements agreed as part of the withdrawal agreement, so before the trade and cooperation agreement. And for the purposes of today, keeping it very high level, it's essentially a set of schemes where you may be able to identify that someone who has been resident in a member state, including the UK, before what we call IP completion day, which was New Year's Eve, is able to apply and retain the right to live and work in that member state, either for a certain period leading up to an application for permanent settled status, or they've already been in the territory for long enough to get that settled status. So we have that legacy that carries over. For frontier workers, it's probably a longer lasting legacy. It's essentially a rule that if you've been commuting across the border to work in a member state which has not been your principal place of residence, you should be able to get a permit to allow you to continue doing that. And that permit could go on, in theory, without end, so long as you can continue to show that you qualify as a frontier worker. So you've got those bits coming out of the legacy of of Brexit. I know from the questions that we've had come through that people are looking at those. Of course, a big point from the UK perspective is that at the moment, although there's been lobbying by the Mayor of London to get an extension to it, the deadline for applying under the EU settlement scheme is the end of this month. So there's not a lot of time left to apply. If you're a sort of a standard applicant, you're not applying as a sort of family member that's applying to join and somebody who's already under the scheme. The big shift, of course, is that British nationals, excluding Irish nationals, going to the EEA, well, we're not EU citizens anymore, we're third country nationals. So how will we establish, if we don't benefit from an equivalent to EU settled status or frontier worker rights in a member state because we've been present there before, how do we move in and out and around Europe? Well, you've got Schengen visits, but the issue there is a visa code governs the Schengen arrangements, and that's into most of the EU member states are part of the Schengen area. But they don't define or codify what business means in terms of a business visit across the member states. So you then have to look and say, which actual territories are you going to be in Europe, and what is their approach to the issue of business? You'll then have different work permits and visa requirements for the EU. So if I give you an anecdotal example in Switzerland, when I looked at that previously for a non-British national, but now the sorts of things you look at with British nationals, it's a requirement for degree level qualifications. If you needed a work permit, because you weren't just doing stuff that qualified as a business visitor, you need to be able to show that this role couldn't be filled by someone from Switzerland or the European Free Trade Area. So there's potential complications there. You've got a blue card scheme, which is the European Union's attempt to create a blanket sort of set of visa entitlements and a visa for the whole area. But it isn't anything like free movement in reality at the moment, because you get your blue card for one member state. It doesn't mean you can just freely move around and work in all the others. And it's at most really just a harmonizing of process and broad rules and requirements. But the point is the requirements are not the same in every member state, and you'll usually need to have an employer presence in the member state as well. We've got EU nationals coming to the UK if we flip it around. So this is slightly simpler in that you have one set of rules in terms of coming inbound to the UK. If you're an EU national who can't show you'd already been present before Brexit and have some rights linked to that, so you're effectively a third country national to the UK. It's one set of rules to the UK, not like 26 different set of rules potentially if you're sending people out to Europe. So that is easier, but typically you're going to be looking at business visitor. So that's for stays of up to 6 months. It's a different period, whereas you're going into Europe and the Schengen area as a business visitor, it's 90 days in any 180-day period. So you're looking back to see how many days you've spent in the last 180 days. Up to 6 months as a business visitor, but very clear rules on what's prohibited and permitted. You can't take up work or employment. You can do certain, fairly long list of different business activities you can do. But the key bit is making sure that you're on the right side of the line in terms of what you do if you come in as a visitor. And then there's visa sponsorship. Lots of people on this session will be looking at it. Becoming a sponsor if you're a UK employer with the right setup, senior individuals to own and manage the compliance duties, either to bring people in as a skilled worker or possibly under one of the T5, the temporary worker routes, creative workers like entertainers or sports people, or intra-company transfer, moving someone from an employer of your own that's connected to you in Europe, for example, to the UK. And just quickly, the EU's trade and cooperation agreement, it's not having the meaningful effect on the ability to move people around to work post-Brexit that we might have hoped. It's essentially a slightly improved version of the rules around what's called Mode 4 mobility under the WTO rules. It's very sector specific. There's about 200 pages of annexes to the agreement where you have to look and see whether the type of business and work you'd be doing falls within one of the sectors and the types of service provider. And then you have to look and say, okay, with the countries we're looking at, does that country comply with these rules, or have they said they're unbound? So for example, Cyprus says, we're not buying into the trade and cooperation agreement in respect of tourism. We're unbound by that, so we'll still have completely our own set of rules. And even if they are bound by the rules, how are they implementing the trade and cooperation agreement rules? In the UK, for example, if you're sending someone in, you have to go through what's called the Tier 5 international agreement route. Well, that requires the customer to be a licensed visa sponsor and to sponsor the visa for the service provider's employee who's coming from the EU member state. And there's only about 140, something like that, who are actually signed up to be a sponsor for that. So difficult, complex, possible routes, but limited benefit from the TCA. So that's a very quick overview. There's lots to look at. There's often ways through it all, but it's a very mixed picture compared to the easy sort of free movement landscape we had before. I'm going to hand over to Sanjukta now. Sanjukta, you're going to pick up on the global mobility, social security payroll in this context as well.
Sure. So if you're looking to do business, then finally, from the global mobility perspective, I'd like to say that the issues and the considerations and the areas of risk remain same and are very similar to what we discussed or what I talked about earlier on in this session, in that as an employer, you will have to think whether there is a withholding obligation, whether there is, whether you need to run a secondary payroll, whether you need to withhold tax, whether Social Security applies. But what you have to remember is that the approach should be proactive rather than reactive, and will largely depend on the commercial decisions that the business takes. And going back to what Nick talked about earlier, how's the business going to be structured? Is there going to be the need to establish an entity in that foreign country? And going back to what Adam talked about, well, are you going to be able to send the people that you need to send to the location that they need to be, and doing the kind of work that you need them to do? So all of these sort of issues will determine what the employer and the individual needs to do from their sort of payroll and personal tax perspective. So I've kind of selected a couple of random examples to bring out the differences and the different sort of planning opportunities that employers and employees might have when you're thinking about this sort of cross-border work situation. So if you take Italy, for example, the foreign employer, or say in this case, the UK employer, has no permanent establishment or corporate presence in Italy, then the employer, the UK employer, does not have any obligation to register a payroll and deduct withholding taxes, but they do have an obligation to register for Social Security. So for instance, in situations where for an A1 certificate or a certificate of coverage is not available, then the employer needs to register for Social Security purposes and then calculate and pay over Social Security in Italy. The employee may not have a filing requirement if they've not stayed there long enough, but if they do, and if they do find that they've become residents for Italian tax purposes, then they will suddenly find that they are liable not only for taxes on employment income, but they come under this regime of wealth taxes. And that might come as a big surprise, because suddenly they will see that they are liable for wealth taxes on their worldwide wealth. And it can be a nasty surprise, especially if the employer is sending these people to Italy and they've then become resident there, triggering this wealth tax obligation. It can easily mean additional costs for the employer that they perhaps didn't account for. And then if you talk about Netherlands, well, there is really no de minimis or minimum number of days below which it is safe to say that you don't have any reporting obligations. However, they have what is called a 60-day rule, where if you're assigning individuals or intra-company sort of assignments, then it is possible to exempt individuals from Dutch filing obligations for up to 60 days, but this depends on certain conditions being met. They also have a very advantageous ruling, which is called the 30% ruling, which again, in situations where the employer has sent somebody to another group entity, the individual can be paid 30% of their employment income or salary free of tax, provided they meet certain conditions. Again, that they've not spent the last 24 months within a 150-kilometer radius of the Dutch border, and that the filing or the application has been filed within 3 or 4 months of their arrival in Netherlands, and so on. So if you're thinking of formal assignments, make sure that you have assignment and tax policies in place. If you are considering ad hoc movements such as facilitating remote working, then do sort of plan in advance, take the appropriate advice, and then consider all the issues before you let that arrangement carry on. So on that note, I think we will move on to our final Q&A section. Nick, this one, the first one's for you. Somebody has asked, I heard that there can now be withholding tax on paying dividends from the EU to the UK. Can you just say a bit more about that, please?
Yeah, okay. When we left the EU, we also lost access to the EU directives. Previously, there was quite an important directive. Not many people might have appreciated they were using it, but if you paid up a dividend from a subsidiary to a UK parent company, then typically this parent and subsidiary directive would have meant that there was no withholding tax. As those directives have now fallen away, we're just looking at treaty rates, and some of the tax treaties, probably about half of them actually with the EU, do give a withholding tax right to the paying country. So typically a key example is Germany, for instance, 5% withholding on dividends now coming in from Germany. Other jurisdictions that sort of come to mind, Italy, Portugal, Greece, there's a number of countries there which do have withholding of rights. You actually have to look at whether they're going to apply them under their local rules. But yes, now the movement of funds and the payment of dividends or interest and royalties, actually the loss of directives here from the EU means that treaty rates apply, and there can be withholding taxes now. So that needs to be factored into any structuring that people do around the EU.
And do we have tax treaties with all countries, Nick?
All EU countries, but not all countries globally. There's a few clear exceptions. Brazil is a big one. I recently was doing business with a client in Lebanon. There's no tax treaty there. Peru's another one. And the thing about tax treaties as well is they do change. Some of them are being updated. If you look, for instance, the treaty with New Zealand, it goes back to 1983. The treaty with Russia, it goes to 1994. Even Luxembourg, I think, goes back further. These are quite old tax treaties, and the revenue will be negotiating and modernising them. So we've just seen new treaties go into place with Jersey, Guernsey, and the Isle of Man. And there's new provisions coming into these treaties as well. So out of the OECD BEPS project there, base erosion profit shifting, there was quite a lot of anti-avoidance clauses that now have been dropped into existing tax treaties. So one of the things which I sort of touched on earlier was around this corporate residency rule. And corporate residency does come up in tax treaties, and there's a tiebreaker in there. It previously used to be based on where a company was effectively managed. If you've got your effective management in the UK, even if you incorporate it overseas, that company would likely be tax resident in the UK. Tax treaties now are typically moving on to competent authority assessment, which is perhaps even a little bit more uncertain, but broadly that means the two tax authorities will now decide. And they'll look at a range of factors. Where was it incorporated? Where are the key people based? Where's the activity of the company being conducted? But it is down to now competent authority assessment. And even the PE, permanent establishment clause that I mentioned, that's changing as well. There used to be this possibility of sort of fragmenting your activities and not giving rise to a permanent establishment. And now they've got some anti-fragmentation clauses in there. So you do have to look quite carefully at treaties and how they apply. They're in place, they're amazing and massively important, but clearly, they've got to be looked at on a sort of a case-by-case basis.
Thanks, Nick. Moving on to you, Adam. There's a question that says, how can we best plan and prepare for the immigration requirements associated with sending people to certain territories for business and or work?
Yeah, well, the big challenge is this point I made about there being different rules in different territories, because different member states interpret business differently for visits. They'll have their own approach to work visas and permits if you're outside of the EU club as British nationals, not Irish nationals, but still get the benefit of free movement that British nationals are. So you have to do one of two things. You have to really do your homework and get to know the ins and outs of that local system, which you could do by spending lots of time yourself, or you need to engage expertise and knowledge through a team like us and a local advisor to say, look, I'll give you the situation, you shortcut me to the rules. Is this going to work? And if so, what do we have to do to make it work?
Right, I'm conscious of the time. So Adam, very quickly, final question for you. Will UK-based employers need to have an entity in a country in order to legally hire people in that location?
It depends. Yeah, I think, well, Sanjay, this touches on both of our areas, I think.
Yeah.
We'll have seen it when we work together and look at this issue. If you take, for example, the Netherlands, when I've looked at that previously, don't take this as being confirmation of the absolute up-to-date position. Often this type of work permit or visa you're looking at requires a local employer to be endorsing. So that would say yes. In other scenarios, perhaps not.
Right, great. Thank you, Adam. So shall I hand over to you for concluding and doing the final poll?
Yeah, there's a final poll here. If people can let us know, this will help us to be planning for what we're doing and what we're doing. Which areas, having listened to all of these issues that need to be worked through, will you be focusing on most in the short term? Will it be business visits, work visas into the UK? Will it be that issue, but looking about sending people into Europe or even the rest of the world? Will you be focused mainly on your obligations for cross-border remote workers, people you've still got to sort of clean up and get your head around from the pandemic? Is it a policy framework for remote workers and assignees under the sort of global mobility heading? What is it about setting up operations outside the UK? Because you're hearing some of the issues we've talked about and thinking we probably are going to need an entity. And what about tax efficiency, structuring more generally? So if you can give us a sense of where everybody broadly is in terms of their feeling of priority, that'd be really helpful. And once we've got that, I think we're going to give, we've challenged ourselves to give a brief sort of 30 seconds to a minute takeaway of what we would be recommending you do in each of our three areas if you're looking at this now, aside from obviously, you know, coming to us and talking that through with us further if you've got particular scenarios that you need to identify and work through. So we're just waiting for the result of the vote to come through. Okay, so slightly ahead is the global mobility policy framework. So for dealing ongoing with remote workers and signees, how do you create an overall structure and policy for that? Another big area is managing the cross-border workers displaced by the pandemic. So it's dealing with that hangover from pandemic. Business visit and work visas into Europe is also at 15%. So there's a spread across a lot. The lowest one of all, though, is bringing people into the UK. So that's an interesting one because that's looking at, you know, what are the demands for skills and talent and labour in the UK. Perhaps that's because people are getting their head around that already. But it's interesting that there's almost twice as much of a vote towards how do we get people into Europe than how do we get them into the UK. So very, very helpful. We will just wrap up, I think, if we can move forward, just to touching on our quick 30-second kind of recommendation from each of us. If we start with Nick, then Sanjukta, and then I'll go last, gives me some time to think. What we would say we'd recommend employers to be focusing on, and let's look in particular at the doing business in Europe going forward. Nick.
Yeah, I'm sorry that I've not had a chance to answer lots of questions that have come in, particularly most of them seem to be around this permanent establishment issue. I understand that. Good question here from David O'Malley, which I think encapsulates it. With remote workers and the authorities giving informal approval of PE is not created and relying on OECD guidance, how can you be assured that it will in fact be the case, or how long the arrangements can continue? I think the point really that's coming out of this is that you've got to now start looking at this on a specific case-by-case basis. Get your facts on a particular jurisdiction, and as I said right at the beginning, we do have advisors in all countries where we can get that local support, and I think it's important to reach out to the local advisors because PE is actually determined differently in different countries. Different authorities are looking at it and different outcomes, so this has got to be looked at on a case-by-case basis.
Yeah, very good. Sorry, over to you, Sanjukta.
Yes, so from my side, my perspective is if you have remote workers, then it's very essential that you monitor each situation as closely as possible. Be aware of where your workforce is at all times, and then take appropriate advice, not just in the UK, but also in those overseas jurisdictions, so that you give yourself plenty of time to consider the issues and plan in advance.
Yeah, I think for me, it's a similar sort of message. It's about the planning ahead. Whether that's internal, knowing that if, for example, if you sit within the HR function or you're in the sort of corporate management area of the business, and it's a larger sort of business where there's different parts, moving parts, early indication from team manager, team leader, wherever it comes from, as to what a move is going to be and when, because it's all about pre-planning and preparing. And I think some things you can do before you even know exactly who might be suddenly working where or is going to be moving to a certain place is try to get a sense of the areas in which people are most likely to be present, the way that your organization operates, where are they going to be, and think now as early as you can about, well, what are the broad rules, and maybe take some advice about what are the broad rules and limitations on that. Maybe you've got 3, 4, 5 countries that the vast majority of people moving in and out of borders are going to be going to. Get a handle around that at high level at the very least. And that will give you an ability to immediately start thinking about and discussing internally the opportunities and limitations, if there are any, when an example in that territory comes into place. So looking at it early, really trying to get a good sense of the framework you're operating in, until such time as we have a sort of lovely single set of rules. One of the questions, again, like Nick, I haven't been able to answer every question. One of them was, where do we find the list of all the rules for all of the countries and what the requirements are? We're slightly more jaundiced in that we work in this area a lot, so we hear that and think, well, that would be great, you know, but there isn't. And until we get, and it's a good project for the EU and the UK to work through their Trade and Cooperation Agreement Committee, for example, to try to build a helpful overall picture. We don't really have one. If someone's found it, let me know. So you don't really have a one-stop shop. You can just go and look at all the list of rules. You've just got to try and engage, pull the right information from the right people as efficiently as you can, and then try to keep on top of it so that you're not got that steep learning curve every time you look to do a move. So we've had lots of questions. If anybody's put down a question, they've put themselves as anonymous. Obviously, we're not able to work out who you are. If you are looking to get some more guidance on that particular question, you just need to ping us an email and let us know who you are. We're obviously happy to talk through, as we've said before, these issues. And it may be that one or two or all three of us would need to walk through the issues. We hope that's been a really helpful overview of the 3 areas, how they overlap, help you to start thinking about planning and dealing with the issues. Thanks to Sanjukta and Nick again for doing the session jointly in this way. Hope everybody's enjoyed it, and thanks very much for attending.